Sir, are you still at Cumberland
I'm
Street?
not agreeing to any of these proceedings because this
you don't have to agree to them, sir. I'm not asking you if you agree to them. I'm going to set it for final pretrial.
Wait a minute, you trying to be my lawyer too? You trying to be my lawyer?
No, I'm not trying to be. You told me, sir, you told me you didn't want a lawyer. I'll give you a lawyer if you want one.
I don't need a lawyer because I haven't committed no crime.
Court, I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide first-hand knowledge. All right. $1,200 every minute I'm in jail.
Today, we have two contemptuous sovcits on the docket. Our first case takes place in Judge David Hoffman's courtroom, where a cranky sovcit defendant didn't even bother to show up in person. Instead, he decided to call in by phone and shout out a multitude of fiery objections on the record. But Judge Hoffman is apparently not one to back down, matching his energy and dishing it right back at this disgruntled defendant. Could this heated back and forth end with the judge issuing a contempt charge? Then, case 2 brings us to Kansas in Judge Mott's courtroom, where a defiant sovereign woman named Ashley Clark is attempting to argue that the court lacks subject matter jurisdiction and that the state is nothing more than a fictitious plaintiff bringing bogus charges against her. Judge Mott's patience is being tested by her staunch defiance and relentless word salad. But are Ashley's long-winded sovcit antics the only reason to have her escorted out in handcuffs? Or is there more to this story? Stay tuned to find out.
Mr. Smith on? Mr. Smith, are you there? Mr. Smith?
Oh, yeah. You got
hello. All right. Mr. Smith, you're not represented. Did you go to the Office of Assigned Counsel or did anybody contact you from OAC?
No. Well, I didn't request no lawyer.
Oh, because all right. So you don't want a lawyer in this matter?
No.
Right, you don't want a lawyer in this matter?
No, right. Because this is a victimless crime. I don't need no lawyer.
Okay. Well, what we're going to do is we're going to set it for final pretrial. Maybe you can talk to the, what?
I object.
Why are you objecting?
Is this a court of record?
Yep, it's a court of record. We're recording it. All right, sir, okay. I'm telling you what the court's going to do. We're going to set it for final pretrial. Listen to me, sir. That's what the court's going to do. Are you still at Cumberland Street? Sir, are you still at Cumberland Street?
I'm not agreeing to any of these proceedings because this
you don't have to agree to them, sir. I'm not asking you if you agree to them. I'm going to set it for final pretrial.
Wait a minute. You trying to be my lawyer too? You trying to be my lawyer? No, I'm not trying to be.
You told me, sir, you told me you didn't want a lawyer. I'll give you a lawyer if you want one.
I don't need a lawyer because I haven't committed no crime.
Then why would the court be a lawyer for you? Are you still at Cumberland Street? You
entering pleas and things on behalf of.
No, I'm not, sir. You're not guilty right now, and you remain not guilty.
And I ain't guilty because I ain't committed no crime. There's a victimless crime. How is you gonna charge me?
I got you, sir.
What do you have a victim? Thank you. Do you have a charge against me? You have a complaint against me? That's what you said.
Yes, I do, sir.
Okay, then I want those transcripts.
Yes, I do, sir.
Then I'll be asking for those transcripts.
All right, you do that, sir. We're going to set it for final pretrial. We're going to mute this gentleman. We'll set it for final pretrial. Thank you, sir.
State versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one, you qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab them real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir, thank you.
All right. Ms. Clark, any opening statement?
No.
All right. State may call this first. All right. Mr. Hollis, please raise your right hand. You swear everything you're about to testify to is true and correct to the best of your knowledge, so help you God.
I do.
All right. You may inquire, Mr. Marcinski.
Sir, will you please state your name for the record? Chris Hollis. Mr. Hollis, what's your current job occupation? I'm a court services officer. With the 30th Judicial District? Yes. In that job occupation, were you assigned the supervision of a Miss Ashley Clark? I was. That supervision being for an endangering a child underlying 12-month sentence? That is correct. On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs? Yes. How is it that that test was performed? A UA sample. And what was the result of that UA sample from Miss Clark? It was positive for methamphetamine. As part of her duties to be on probation, is she required to report regularly? She is. Did you order her to report on June 2nd, 2023? I did. And did she appear on that day? She did not. As a condition of her probation, either ordered by the court or by the court service department, was she to complete an outpatient treatment program through Sumner County Mental Health? She was. As far as your current knowledge through today being August the 31st, has Miss Clark successfully completed that outpatient treatment? She has not successfully completed it yet. 3, were you advised by local authorities of her being arrested for a new crime? Yes, and I did. I received that, and apparently she has new charges. Okay. As a condition of her probation, is she required to report any, we'll say, negative law enforcement contact with her probation officer? Yes, within the next business day. To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office? No, she did not. That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
All right. Do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right. Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now, I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay.
Open and shut case, Johnson.
Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide first-hand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Great. There you go.
Will you make sure my mother gets this notebook, please?
Yes. Is she here?
She's right back there.
Okay. You want to add some?
Yes, please.
This one?
And there should be 2 cards in my back pocket too. I want her to have this. I think there's one. Maybe that's my only one. I'm not sure. I don't know if there's anything in that one. No problem.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.